So let's move on to the next item, which is the presentation from the citizens group. So we're roughly an hour and a half in, so we want to hear from others. You have the floor. Okay, now let's make sure that we've got the right version.
It's titled at the top, Mr. Chairman. You should see presented by the study group, citizen study group at the top.
Yeah, but I just want to make sure that we have the
It
version
says September
labeled.
12th on it, John. Does it say September 12th?
Yeah, well, yeah.
So that's September 12th,
Okay.
2007.
This is the final one, right?
Let me just bring this to the public's attention, because I know we get jumped on a lot because we don't post things in a reasonable time frame for the public to review. Some of these documents and changes came in simply hours before this meeting, and it's only fair on both sides if we try and adhere to the 72-hour rule on both sides. I just think that's fair. I guess not, but I tell you, we strive to always maintain at least 72 hours. On normal routine matters, we strive to maintain a 2-week notice for the public. And we would just ask the public to give us a little bit of time to review documents submitted to this body hours before a meeting.
So, the floor is yours.
Good evening, Chairman and Commissioners. I know this has gotten called a Friedman document. It's not. But I'm speaking for a group of more than a dozen concerned residents of Sandoval County, and we call ourselves the Sandoval County Oil and Gas Ordinance Citizen Study Group. We educated ourselves on the issues of oil and gas operations, and we've reviewed numerous local government ordinances for oil and gas producing communities, taking into consideration state and federal laws governing oil and gas activities. Oil and gas development is a risky industrial activity with potential significant benefits for the county. However, there are financial, environmental, and legal costs to the county which must be balanced against the benefits. And we want to ensure that oil and gas development in the county is done responsibly. We've taken the posted planning and zoning gas draft September 2017, the one that you've been talking about, and modified it to address our concerns and those expressed by the general public at previous public meetings. And tonight, we wish to present the changes we recommended to that draft. Besides the items at the detail level, we modified the document keeping in mind 6 principles to protect the health, safety, and welfare of county residents. First, an open and transparent application and review process, which includes public notice and adequate time for staff review and a public hearing as required under special use. Second, baseline measurements to provide a basis for evaluating impacts on noise and on air and water quality by oil and gas operations. Third, independent monitoring and inspection to catch problems before they become disasters, and also to provide incentives to operators not to cut corners. Fourth, reimbursement fees to be paid by the operator to cover the direct costs of the county for contracting independent monitoring and inspections. Fifth, meaningful enforcement measures for egregious or repeated violations, such as suspension or revocation of the operator's permit rather than the trivial dollar fines that the state allows. And sixth, adequate financial insurance to recover the cost, environmental plugging and abandonment damages that are not covered by the state. It's important to take your time to make sure that you've got the correct balance between industry, business needs, and protecting the county. Chairman Ryan and Commissioners, we're ready to go through the details of this citizen ordinance with you, and I'll say we are here to work with you in coming to a good product. So I'm going to turn this over to Mary, and I'm just going to sit here mostly like a fly on the wall.
Not quite a fly. Thank you, Commissioners, Mr. Chairman, for allowing us to present our concerns about...
Can't quite hear you, Mary.
You can't quite hear me? Okay, our concerns about the draft ordinance. We have, I mean, I'm really impressed. I've done lobbying for 30 years. I've been involved in environmental issues, and quite often at the state legislature, things happen pretty quickly. But this group of residents, and I think you should be very proud, a lot of them are from Placitas, are so intelligent and so caring and thoughtful that I am very impressed with the way they've been thinking about this. And they have listened very, very carefully to your concerns, that it not be in conflict with the federal and state laws. And there is also, I think, something that has come out of this, which is that what this is proposing is really a Sandoval County oil and gas ordinance smothered in the green chili from Sandoval County. It's not Rio Rivas, it's not San Miguel's, it's not San Juan's. It's a lot of the language that's in here is actually the work of your very staff. It is, and some very creative thinking on the part of the group that literally spent hours and hours thinking about what kind of regulation do we need, not to discourage oil and gas, but to protect the residents, to protect our environment. So I don't know, I know you have a time constraint, Mr. Chair, but we have a lot to say, and perhaps I should go through it section. I'll do it as quickly as I can.
Right.
in terms of the first thing I think that we were concerned with is that the citations under 1.2 statutory authority are actually inaccurate. NMSA 1978 section 437.9, and that's what follows, actually misses 1 through 8. And it really should include 1 through 8. And the citation for NMSA 1978 section 321 is a very strange, has nothing to do, it's municipal law, and has nothing to do with anything to do with oil and gas. So those are inaccurate citations, and so we have included the standard citations that have been in your draft ordinances. And you'll see.
Mary, can I stop you for just a second?
Yeah.
Can I just hear what the word is?
I did look at those citations. I actually figured out why it was 4-37-9 did not start at 1. 1 essentially through 8 is essentially the procedure for getting an ordinance passed. So that's the publication procedure that I just talked about at the beginning of this meeting, things like that. The actual meat of what powers the county has is in 9, the rest. The reason the one about the municipal 3-2-1, the reason that would have been included is actually in the county section of the statutes, it says counties have some of the same powers as municipalities. So that's why that would have been included as some, I mean, it is more accurate to say it probably should have been 4-37-1. But like I said, that's kind of that's the title of the act, the purpose, things like that.
Given this issue and 26 pages more of this issue, do you guys think that maybe you should cooperate with staff? You guys should get together and go over this instead of here, instead of us listening to what maybe you guys should do in private?
I actually have talked to them. I don't know if the staff at PNC have talked to them. I did talk to them very briefly last Friday. That's when that was brought to my attention, and that's when I did look at that. The rest of this, I will let them proceed with their presentation. There are some legal things I think wrong with this, but I will let them deal with it.
Mary, do you have any suggestions as to getting your ordinance approved or more streamlined for staff? It seems like they have issues with it. And if we're gonna go through the whole thing and we can't do anything with it, I don't really know
Well, my understanding is the purpose is as we go through this, you may want to make changes to the ordinance you just discussed. You've been discussing, and that's not a final ordinance. If I'm wrong, then I don't know why we're here.
No, it's definitely not a final ordinance. I just, there's already, issue as far as details, as far as,
Well, we could pass that on, but I have Article 37 right in front of me. And it, first of all, gives the county its powers. It has, section 437.3 is enforcing county ordinances. Why wouldn't you want that in your oil and gas ordinance? It gives you the statutory authority. It's very standard to cite the sections of county ordinances, county laws, this is Article 37, and it's not a big deal. So I find it very strange that the only section is the ordinance's recording and publication effective date is section 9. That doesn't make sense to me. And we can move on to that legal issue. The other one is, the municipalities one is the petition to incorporate area as a municipality. What on earth has that got to do?
So let me make a suggestion.
Yeah.
Okay. If you have issues with the legal language, you've got between now and whatever date, in September,
21st.
when this is likely to go to the county commission to work on this with the county attorney. We're not going to tonight decide on statutory sites, but if you can get to the meat of what you're proposing, that will, that's what we're particularly interested in. Water,
Yes.
air, roads, emergency
Noise.
services, all the things that we discussed in the work session.
Well, there are other issues. There's section 1.3 conflicts and the state and federal preemption. You have virtually given away, given this language, your power to challenge a federal or state person that says, no, what you're doing is in conflict. You're saying whatever they say, they're in control. And that is a tremendous power for a local government to give to a state and federal authority. You should always have the right to go to court. Of course, you want to discuss with whoever's in charge.
So just
But I
point
think
out
that-
the language in your draft. that
Okay,
deals with-
well, I think you see it right away. It's been deleted on page 2, 1.3. Should a conflict arise between any provision of the ordinance and any state or federal law or regulation, the county shall defer to the authority of state and federal agencies.
Yeah, okay.
And
I know
that-
the
and-
language is in it. How do you want to change it?
Just delete that sentence. That's all. Well, every cross out in here is our cross out. And then the other suggestion we have is, on the preemption, we do a cross out. To the extent this regulation conflicts with any federal or state statute or regulation, this ordinance is preempted in the applicable federal or state statute or regulation shall control.
Yeah.
You're giving away a huge power that a local government has. In addition, then we've added and in all your drafts, original drafts, you have scope, purpose, and findings, which are just standard in ordinances and is totally missing. Rules of interpretation are not included, and that, again, an ordinance is for the public. And what words mean, what does shall mean, all of that should be standard in this. Incorporation by reference, I don't know whether you're incorporating by reference, but there are some definitions in land use that need to be included here. We're
Okay, but wait a
putting one,
minute. I'm following, but it'd be a big help if you said, I'm on page 4,
page 4,
section 2.1, which
definitions,
is
article 2, section 2.1, is rules of interpretation. That's standard in an ordinance. Yeah.
okay, you're killing us, man.
Well,
There's a lot of information, so just take it.
Yeah.
okay. Well, if
You
I
have to
can
be
take
very
this,
slow and very
okay.
concise, and then you have to tell us exactly what you want, and where you want it, and how
Okay.
you want it.
Let's-
And you're just rambling, and I'm losing you.
Section 1.4.
We didn't hear that.
To the extent this regulation conflicts, you'll see the cross out. We want that crossed out.
Where? On the-
It's
to the
section
extent-
1.4, state and federal preemption. That's on page 2.
To the extent this regulation conflicts, is that what you want us out?
Yeah. Because it already says, the ordinance does not replace, alter, or amend any federal and state statutes applicable to the oil and gas industry, including but not limited to the statutes listed below.
Mr. Chairman, can we discuss as we go, maybe?
No, let's
Well,
let him go through. It's gonna-
This is a major policy issue that the county commission
I
has
understand
already
it's a major
determined.
issue. I'm making notes. I'll come back to the
Okay.
stuff that we need to discuss.
That's why we want it crossed out, it's an immense issue. Page 3, you'll see scope and purpose and findings. Those are standard in an ordinance like this, and they certainly were in all the drafts that the staff produced. And so we just took that from their like, for instance, their last August draft. It was all in there. And then on page 4 is definitions and rules of interpretation. Again, that standard language that should be in here in terms of what words mean. And then on section 2.2, incorporation by reference. That's a big decision. A lot of, to refer to oil and to OCD definitions when there's some that are missing. For instance, OCD doesn't have oil and gas facility. You use that term. Oil or gas facility needs to be defined. It certainly is defined in your August draft. We put pollution here because it's, and this is again the definition that comes from your standard operating procedures in your August draft. So we're not taking anything that we've created. This is something that's already been, drafted by your staff. Then on page 5, this is a big one, an extraordinarily big one. What this current draft you're discussing, what you call the Stoddard draft, essentially is permissive use. There is no public notice and no public hearing process. And planning and zoning and the county commission have no authority. Essentially, it's a checklist, and that's what Director Springfield said. This is a checklist, and if they fill the checklist, then we are required to give the permit. The public has a right to know. They certainly have a right to know about sand and gravel. They certainly have a right to know about other industries in the county. And it would seem that they should have a right to know and get through notice procedures and public hearing requirements. And special use it would allow that process. So that's why we put the change in 3.1 to essentially remove permissive use section, and you are assigning it to rural agricultural district. And I think that's a kind of a, I don't know how to put it, but I think in the rural agricultural district, there's an intent section. And the intent is rural and agricultural and residential. There's nothing in that intent that talks about heavy industry, industrial. And it is, and the list of things like barns and homes, guest houses, there's nothing in that list of rural residential agriculture that comes close to what oil and gas is. So putting it in that piece of your ordinance not only denies the public right to notice and hearing, but it also is putting it in a section of the ordinance that truly legally makes no sense. So that's why, those are two reasons why we think that you really should consider putting this industry in a special use category, not to allow the public to have say, and that includes neighboring tribes and municipalities that have have said that they want to know about this. And this is just standard operating procedure. Sand and gravel has to do this, so why shouldn't mine? And then, of course, permit review, then that you're getting into who makes the decision. And and your permissive use, it would be Mike Springfield. He makes the decision, not you all. And so we think that the Planning and Zoning Commission and their special use, that Planning and Zoning Commission makes a recommendation to the County Commission. Under conditional use, it would just stop with you all and they'd have a right to appeal if they didn't like your decision. But in both cases, conditional use and special use is public notice and public hearing. So the public can have some say into what's happening. This is behind closed doors. This is not transparent. This is not the way a big industry like this should be included in our. Very, very big decision for you all to make. Then on page 6, when a permit has been issued for the drilling of a well, this is the black refers to the original Stoddard language, so that's not the red that you were just looking at. When a permit has been issued for the drilling of a well, such permit shall constitute sufficient authority for drilling, operation, production, by the permittee and its employees, agents. So what's missing in that is also the necessary facilities, like storage facilities and other facilities. It's not just production. And there's gathering lines, and gathering lines have become serious problems, and that we'll discuss a little bit later. But they can really cause enormous problems for PNN and home builders who may not know where they're located off-site. And so you really the permit needs to include gathering lines and necessary facilities and only those other elements listed on the site plan, which you require under Article 5. The other issue is, and I think this is a mistake unless you corrected it, Section 4.5, it says it is unlawful and an offense for any person acting either for himself or herself, or acting as agent, employee, independent contractor, or servant, for any person to knowingly, and I want to remark that, you remember that, knowingly drill any oil and gas well, so it's not just any well, it needs to say oil and gas well, within the county and jurisdiction of this chapter. That doesn't make sense. It should be within the county, without a county well drilling permit. It should be really clear. And then we have added, because this is far more complicated than our staff, our planning and zoning staff have ever had to deal with, and I remember very well the complexity of Sandridge. So we have said if it is necessary, and that's up to them, for the county to hire consultants to assist in the review of an oil and gas permit application, consultants' fees shall be assessed to the applicant. And that's voluntary, so your staff needs the notification requirements, and I have been involved in state statutes for solid waste and many other types of environmental laws. And so the notification of the New Mexico Solid Waste Act, is cited here, 74-922, is a really good, clear notification requirement, because who reads the legal notices? So that you have to not only put it in a legal notice, but in a paper calculated to give the general public the most effective notice, so some large notice. And when appropriate, shall be printed in both English and Spanish, and posted in at least 4 publicly accessible and conspicuous places, including the proposed or existing facility entrance on the property on which facility is or is proposed to be located. I think that's just a normal notice requirement that is extraordinarily important. All of this, B, comes from your August draft and your standard operating procedures about the notice and who's noticed. And I think what's extraordinarily important is that there's specific notification on number 4, page 6. All government and Native American Nation Pueblo agencies within 3 miles of subject site are notified by the county of any request for oil and gas exploration and production. And incorporated municipalities within 5 miles. This came from language that you all have, and I think that's a very important provision, particularly since I remember Mike Springfield saying that in cases of emergency services where a place like Cuba may not have enough resources, that there can be memorandums of understanding with other agencies. So it's really important that they get involved right from the get-go, from the beginning. And that's what that allows. Posting of applications, again, that's in the August draft, and the SOPs, the standard operating procedures, so the applications are posted 24 hours of receipt, so that people can look and review it. And you've got a lot of intelligent residents and talented people in this community that really deserve to read read that stuff. Permit conditions is not mentioned at all in this ordinance, in this proposed ordinance that you have. Permits should be for a period of 2 years. That's standard for OCD. And if the site is inactive for 2 years, the permit shall be null and void. That's very standard language. BLM is having a problem with all these people that are buying permits and not using them. They're waiting for the market to go up. And so that's fairly standard. And then we added renewals of permits shall be granted to operators of active wells who have no outstanding violations. So that is just something that the renewal, if they're on good behavior, just renew it and let them keep on going. They don't have to go through enormous, complicated process. Change of operator. You can see again, the green is our language. That the operator needs the new operator shall notify the director and provide updated emergency and other contact information within 10 days of the change. There's nothing in the Stoddard ordinance that allows for that says that. How important that would be if there was some accident that occurred and you didn't have, and the ownership had changed and you didn't know whom to contact. Because that updated information is really important. And then, of course, the new operator, and as a standard, submits to you a copy of the applicable permits so that you know that they're legitimate. But we're adding a new requirement for a new operator in Article 5, Section 5, and Section 6. And I'll go over that when we talk about the permit application. So the applicant, we just felt like under Article 5, we thought that was unnecessarily complicated, and it was very confusing from some oil people that I know. So just simply say the operator is required to submit an application for, and of course we want special use permit, that includes but is not limited to the following information. It's very simple, very clear. And then the information, that's all that you all have in your, the black and the red. We would suggest that you include, and you'll see on page 8, receipt. So it's not the mineral rights owner or lessee, and or operator applies for his permit. Then on section 5.2, we are suggesting that when you receive the NMOCD permits, that you also get the materials that were submitted to NMOCD. I think that's important, and it may mean less work for the staff to have some of those materials. The significance in 5.3, instead of each, it's the. You are granting a permit for the proposed well, not each proposed well. And any necessary facilities, because you're including when you define facilities, you're defining in the site plan, you go through it, what you're going to be including. So in the site plan, which is very, very brief under this, I don't want to call it Commissioner Stoddard, shall we say, 0.1. Because there's, I'm sure everybody, even when you have drafts, you always go through a million changes. So site plan, the proposed site plan for the well, not wells, the location of tanks, pits, compressors, dehydrators, pits, I'm sorry, it's deleted, because you'll see that we don't feel you should allow pits. Compressors, dehydrators, and other equipment and facilities, gates, pump stations, tank batteries, pipelines, gathering lines, including the proposed location of an off-site routing of any gathering lines, a diagram of the permanent location footprint, that's your language, and the GPS location of the well, which is important for people to be able to locate it. In order to allow for the county's post-abandonment monitoring and remediation, the applicant shall include a 20-foot access easement to the proposed well and a 30-foot radius easement around the well. Within 10 days of the commencement of drilling, the applicant operator shall update the draft to as built and file it with the Office of the Sanibel County Clerk. What is very critical in terms of gathering lines, when they are built, that they be platted. We put that in there at another point. The reason being is that if off-site PNM drills, or some homeowner drills, and they didn't know that there was a pipe or gathering line there, that you can get accidents. And my understanding from the Oil and Gas Accountability Project, that there are an enormous number of accidents that are occurring with gathering lines around in oil and gas states, that people just didn't know where they were located. And it just makes a lot of sense. I know if I were a home builder near an oil well site, and I want to build a home, and then I tell P&M, come drill, come put in my cable or whatever, and we don't have information, because they look at whatever's platted, they don't have information about where those lines are. There could be accidents, and so that's a real safety thing. The property details, I know you wanted consistency, and I remember the discussion about the 750 feet, but the location, the property detail is not your setback detail. It is just giving you a sense of where is this property located within a reasonable amount of time, so you really get, or distance, so you really get a sense of what's there. And so that's why we put 1 mile. And so that's not a setback requirement. It's just to say, okay, where are the churches, where are the water supplies, where are the archaeological sites, where are the historical sites, where are the assisted living homes, just in general, just so you get a general picture. Noise control plan, we put that later, so that's why this is all crossed out, because that's later. Now 5.6 and 5.7, remember I said when an operator is changes, a new operator comes in, that you will want to look at 5.6 and 5.7. It's referenced on that page. And this deals with, and I think a lot of concerns came with the Sandridge application. There was a company that had been delisted from Wall Street, was in bankruptcy, that had a history of bad environmental history in Oklahoma. The state of Oklahoma asked it to close down 5 of its wells, and it refused to, and so it was a big negotiation thing with that. So and we know that the OCD doesn't look at the environmental history or the financial solvency of a company. And we think that that's important to know whether, are they good actors, are they good players? And to look at it both in-state and out-of-state. And this is asking, it's not the staff to research it. It's just saying, okay, certify this, that you don't have any outstanding violations, and that you are a solvent, and if you have a parent company, that they're solvent. Just so we know that there's a lot of bankruptcy going on in the oil and gas industry, and this is a piece of it that OCD does not ask for, and I think it would be very important for the county to know whether they're good actors. Most of them are, there's no problem with it. but there are unfortunately some bad actors, really bad ones, and I think we saw an example of one. Then in 5.8, certain reports need to be required, we think. One is describing the hydrology, geology, and seismology of the area to be drilled. And that the hydrology is going to be very important in sections 5.8 when we talk about monitoring wells. And a report identifying whether the site is located in a key conservation area as mapped and defined by the New Mexico Department of Game and Fish and the U.S. Fish and Wildlife. Analysis of how the development may impact wildlife and habitat in the area. There's many studies about how heavy industry development, oil and gas is not the only one, can impact wildlife and habitat. And that's very important for our county. It's a very big attraction for tourists. A report describing rangeland quality in the area of the site. I have worked very closely with the cattle growers, and we worked hard on the Surface Owner Protection Act together. And rangeland quality is a very important issue for them. And I've heard many stories from ranchers and concerns about what has happened to them, which is one of the reasons why the Surface Owner Protection Act was passed. Report describing existing historical, archaeological, or cultural sites listed in the Register of Cultural Properties of the New Mexico Historic Preservation Division and that are located in the area of the well site. You can go online, it's very easy, they've got them all there, and you can just put them down. And then what's really important is you allow the applicant to say, okay, we found out that there is a site here, we can drill this way to avoid it. So you allow them to say, we are going to address these issues in this way so that they're not problems. Our noise control plan, and we are recommending the 45 decibel level. And there's a lot of reasons for that. I want to stress how important noise has become as an issue. Wyoming, the state of Wyoming, and Colorado have seen enormous numbers of increases in complaints over the past few years. In Colorado, in 2010, there were 240 noise complaints. This past year, there were 704. And as the industry gets closer to urban or semi-urban areas, and then of course you have people in rural areas, farmers, ranchers, people who have their piece of heaven and think that this is, they're not. I live in an area, Corrales, which is fairly quiet, and I can tell you, a noise like what Steve just did would drive me nuts over three days continuously, and I work out at my home. So that I think the 45 decibel level, the World Bank actually requires that at the receptors, as Steve mentioned, at the edge of the property. Hobbs, by the way, requires hospital-grade mufflers to achieve 25 dBAs. For oil and gas facility for engine motors not electrically operated. And there are lots of ways to mitigate noise. I don't want to go on and on about this, but there are lots of ways to mitigate noise. And as anybody who builds a home knows, it's better to build in something up front than to wait later on when you have to do it. So, and noise is of concern to the oil and gas industry. As well. They recognize that it's become an issue, and there are lots of interesting and creative things that are being done to actually deal with level A noise, and then level C, which is more difficult, and that's a low hum that compressors have, for instance. And there are suggestions that they have totally enclosed acoustical sound barriers. But Alberta, Canada, for instance, lots of oil and gas there, so they don't seem to mind, that is to achieve at nighttime 40, 45, and 56 levels, depending on traffic density. Sacramento County has at the residential property line 45. City of Long Beach, California 45. And Colorado is a different standard, 350 from the noise source at 45, but that's a state law, and the county can't regulate what's on the property of the oil, where the oil and gas site is located. So 45 is definitely achievable, and what I found interesting is Farmington. And Farmington, the city of Farmington says that it can only be one dBA over ambient. And what the Oil and Gas Accountability Project did, they have technical staff, they conducted sound measures at well sites in Farmington. And the noise levels measured at 300 feet from the noise source varied from 39 to 49. And it is that, so it is possible to go down to a 45 dBA level. And we would recommend that. Any facilities outside the well pad are subject to the same setbacks and noise requirements as the well pad. So, there are compressor noises. There are other kinds of really loud noises. And then C is the applicant may apply for a variance if the operator needs to exceed this level for a specified number of days and hours due to drilling, completion, and production requirements. So that variance could say, look, we're going to need it, it deals with the concern that you all had about, 30 days, 1 week. Most of the loudest noise occurs at up to 1 week, as Mr. Padilla said. It really, and then there are occasions when they need to do workovers and other things. And then in addition to the variance criteria described in Article 8 of this ordinance, the applicants will demonstrate that the noise level requirements of 45 decibels is not technically feasible. If they can show that this is impossible to do, given this. But right now, there's electrical equipment instead of diesel, and there's all kinds of things that are being talked about. On page 12, I'm sorry, 10. Am I on 10 or I'm skipping too fast? Talking about skipping fast, yeah. Section 5.10 is the road plan. And we're adding some language, particularly when you deal with oil and gas related truck traffic. It's very different during different phases of what they do. So, the type of trucks that you use, truck traffic in construction, drilling, production operations. So it's nice to know for the road person, what that will look like. Then we feel strongly that the Public Works Department, let's read C. The planning and, B is a traffic impacts study. C is the planning and zoning division director or designee shall convey to the road plan, this is all your language, to the Public Works Department or designee. The Public Works Department director or designee may require modification of affected county roads consistent with county standards at the applicant's expense. I think that's what was your intent, but it needs to be stated. And then we want to reinstate what was in your SOPs in the August draft. The county may require, and it's a may, require the applicant to provide a cash bond security, a letter of credit, or acceptable to the county road improvement agreement for the use of county roads. Emergency response plan, you need to add the emergency response plan must include a section for fire protection and the types of potential circumstances when the permittee will call emergency responders. Being informed about you could have this, and this problem, and that's part of the emergency response plan, is part of organizing and to allow coordination between the health and fire and other kinds of services that may be needed. And then we would include that the applicant provide the county, a vicinity map with these facilities indicated and a document narrative of information that includes the contact information, address, directions, and distance to each facility. The applicant shall provide documents indicating letters of approval from fire, police, and emergency response services, including financial arrangements with these facilities. I understand Cuba is stressed in terms of its services, and so let's, I think as part of the application, we need to know what they would be expected to do and how it would be paid for. And then, of course, any specialized training and equipment, like phone, needed to support county emergency services shall be paid for by the operator or the applicant, because there is specialized equipment that may be used. D actually was a concern of the city of Rio Rancho regarding Sandridge, and they requested a hydrogen sulfide plan. And so the applicant, we put it, since it's the county, not just Rio Rancho, applicant shall provide a hydrogen sulfide contingency plan to municipalities, unincorporated areas, tribes located within a 1 mile radius of the well site for their review and approval in accordance with the American Petroleum Institute's RP-49 recommended practices for drilling and well servicing operations involving wells containing hydrogen sulfide. And then, of course, E deals with the emergency response plan to be reviewed and approved by the fire department and by municipal and other agencies where needed. And we think that's important to include municipalities and other agencies. On 512, proof of bond, it
Can I
just says,
stop you there?
yeah,
Can I take a 5-minute break?
5-minute break, sure.
Yes?
That would be good for me.
Sure.
we're halfway through.
That's what I thought, I'd stop you halfway.